Welcome back. My name is Andrew Stewart, and I'm a corporate lawyer who helps business owners and executives and entrepreneurs build strong, legally sound companies. Today, I'll walk you through the basics of corporate formation, highlight why choosing the right state matters, and explain why foundational documents like operating agreements and bylaws are essential for protecting your future and the future of your company. This is part one of corporate formation basics, choosing the right entity. First, every business owner must decide what type of entity to form. The most common choices are LLCs, limited liability companies, C corporations, S corporations, limited partnerships, or LPs. Now, each structure has different implications for liability protection, taxation, and management. For example, LLCs are extremely popular because they combine personal liability protection with flexible management and pass-through taxation. C corporations, on the other hand, are often the structure of choice for businesses planning to raise venture capital or go public, despite being subject to double taxation. The entity you choose should match your business goals, your funding needs, and your tolerance for formalities and tax obligations. Now, let's get into part two of our corporate formation basics. Here's why the state matters. These are the best business-friendly states to form your business in. When we talk about where you form your company, it's important to know that you don't have to incorporate where you live. You can elect a business-friendly state, and the most popular choices are Delaware, which is always the gold standard. It offers a sophisticated court system, the Chancery Court, massive body of corporate law precedent, and strong protections for directors and officers. Then you've got Nevada, which is known for its pro-business stance, minimal reporting requirements, and no corporate income tax. Then Wyoming is rising in popularity. It's got low fees, strong privacy protections, and no state income tax. Texas and Florida also are excellent options for businesses seeking a large local economy, reasonable regulations, and no state income tax for individuals. Each of these states offer unique advantages, but Delaware often remains the default for companies that anticipate raising outside capital or expanding nationally. On to part three of corporate formation basics, the actual formation process. Here's a step-by-step breakdown of the formation process. Number one, select your entity type. LLC, C Corp, S Corp, etc. Number two, choose a name. Make sure it's unique and complies with state naming requirements. Number three, appoint a registered agent. This is the person or service that's authorized to receive legal notices on your behalf. Number four, file formation documents. For an LLC, you're going to file articles of organization, and for a corporation, you're going to file articles of incorporation. Number five, draft governing documents. You've got operating agreements for an LLC and bylaws and shareholder agreements for corporations. Number six, obtain an EIN, the Employer Identification Number from the IRS. It's necessary for taxes, hiring employees, and opening bank accounts. Number seven, initial compliance tasks. Open a business bank account, get any required business licenses or permits, and register for state taxes if that's applicable for you. Now, it's critical to complete every one of these steps properly to ensure you are legally protected and ready to operate. Next up, part four of corporate formation basics, why corporate documents are critical. Now, let's talk about the real backbone of your business, your corporate documents. An operating agreement for LLCs or bylaws and shareholder agreements for corporations are not optional, even if your state doesn't strictly require them. They are essential because they define the roles and responsibilities and rights of each owner. They outline how decisions are made. Is it going to be by majority vote? Is it going to be by unanimous consent? They set the rules for adding and removing owners. They govern dispute resolution procedures. They protect your limited liability shield, and without them, courts can sometimes pierce the corporate veil, exposing you to personal liability. Now, even a single member LLC needs a formal operating agreement to demonstrate that the business is distinct from its owner. Without strong written agreements, misunderstandings between owners can escalate into costly lawsuits, and courts may treat your business as an extension of your personal finances, which really defeats the whole purpose of forming a company. To sum up the basics of corporate formation, here are my quick high-level points for you to remember. Choosing the right entity, forming in the right state, and having rock-solid formation documents are not just formalities. They are the foundation that protects you and your personal assets, attracts investors, and gives your business the ability to thrive long-term. If you're starting a business, work with experienced legal counsel early. Doing it right on day one will save you years of headaches and thousands, if not tens of thousands of dollars down the road. I do this work day in and day out, so reach out if you ever need guidance. Good luck.